Right, that's it. Should be up and running now. Sorry about that. Oh, wait.
You okay, Graham?
Yeah, you're okay.
I've got a live icon on my screen.
Yep, that's fine.
Okay.
I'll switch my video off now. Sorry about the delay, folks.
Okay, well, good morning, everyone. Thank you for joining me this morning, and welcome to this pre-examination meeting in relation to the appeal by Lidl Great Britain Limited against the decision by the City of Edinburgh Council to refuse an application under Section 42 of the Town and Country Planning Scotland Act 1997 to implement use of 64 Seafield Road, Edinburgh, which is an existing B&M store, without compliance with condition G08 of Planning Consent A 02910996 to permit the sale of food or convenience goods from the retail unit to a maximum of 1,033 square metres net sales floor area. Now, my name is Trudy Craggs. I'm a reporter for the Scottish Government's Planning and Environmental Appeals Division, and I've been appointed by the Scottish Ministers to consider this appeal and to determine whether or not to grant planning permission. Now, hopefully everyone can hear me. Those who've got your cameras on, I can see you fine, which is good. Can I ask you, if you're not speaking, can you put yourselves on mute? And I will do likewise. It just helps with the sound quality and stops it breaking up for anyone who's listening. Okay, so as you all know, this is a virtual meeting, which is the way we're doing things at the moment. It is being broadcast live, and as such will be stored as part of the DPA website archives and will be capable of repeated viewing. Now, I have the discretion during this meeting to terminate or suspend filming if, in my opinion, continuing with the film would prejudice the meeting. By participating today, you're consenting to being filmed. You're also consenting to the use and storage of these images and sound recordings, and of any images or information pertaining to you contained in them for webcasting and training purposes, historical records, and making those records available to the public. If you want any further information on the DPA privacy policy, then that can be found on our website. So first of all, thanks to Graham for arranging today's meeting, carrying out the testing and setting us up and managed to get the live stream on. He is hiding in the background. You'll see his little screen there. And he'll hopefully be able to step in if there's any technical issues. Hopefully there are no technical issues, fingers crossed, but you can never tell. I've switched off every other device in the house. My kids are homeschooling and they're on pen and paper. They're back to basics this morning to make sure there's no technical issues at all. Everyone who I expected to be on this morning, I can see on the screen, and none of the interested parties have opted to take part in the pre-examination meeting, so we're not expecting anyone else, although there may be people viewing this live. So for the benefit of those who may be viewing, can I ask the lead participant for the appellant to introduce yourself and those attending for the appellant this morning?
Mom, my name is Douglas Armstrong. I'm Queen's Counsel at the Faculty of Advocates in Terra Firma Chambers. I'm instructed by Lidl Great Britain Limited. Today, the members of the team that are appearing are David Dury from Lidl, Kim Steele from Lidl, Gordon Rafferty from Lidl, Keith Hargest, Hargest Planning Limited, and Michael Summers from ECS Transport Limited.
Thank you. And now can I ask the lead participant for the council to introduce yourself and those participating on your behalf? Thank you.
Good morning, ma'am. Graham Nelson, solicitor from the council. Apologies, I've just realised that I've got a number rather than my name there, which doesn't help everyone, but sorry, Douglas and I do know each other, so you'll know perfectly well, and obviously we've dealt with each other before as well. Otherwise, from the council, I anticipate most of this, it will be through me, but it may be that it's necessary for the others to speak at times. So there's Lottie Flood also from the council's legal team, Keith Miller, planning policy side in the council, David Gibbon, planning service manager, and Graham Fraser, who dealt with the application.
Thank you. Now, I'm happy that if I'll assume Mr. Armstrong, Mr. Nelson, you're going to be doing most of the talking on behalf of your parties today. If anyone else does want to add in, wave your hand. Although Mr. Armstrong, Mr. Nelson, please feel free to bring anyone in at any time. Just do that, and people on mute to mute themselves, and that's absolutely fine. We'll see how that works out. Okay, so if we go on to item 2 on the agenda, this is really the purpose of the pre-examination meeting. Now, the purpose of the meeting is to discuss the procedural aspects, as I set out in the agenda. The final agenda was circulated on Tuesday, and hopefully you've all got a copy of that. There will be no discussion on the merits of the case today, and I will not hear any evidence. I will be keeping a note of our discussions this morning, and will circulate a note of the key decisions as soon as possible in the form of a procedure notice. That notice will set out all the procedural arrangements that we discuss and agree this morning. So, item 3, the appeal will be progressed in accordance with the Town and Country Planning Appeal Scotland Regulations 2013, which I'm sure as most of you are aware. They can be accessed through the GPA website as well. These intend to ensure that the issues identified for consideration by me are dealt with in the most mode, and that can be by an inquiry, a hearing session, or by further representations. All of the written material already submitted to me, including all of the representations, the appellant's documents, and the council responses, will be taken into account in my consideration of the appeal. However, as I cited in the agenda, I consider that I need additional evidence on some issues. I will now turn on to that on item 4 of the agenda. Now, first of all, I thought it would be useful just to set out what I felt were the matters where there was no dispute between the parties. And I listed that out in the agenda. Now, for those also who may be watching on the live feed, I will list these out. Now, I felt there was no dispute between the parties in respect of the policies against which the appeal should be assessed, and those policies are RET 1, Town Centre's first policy, and RET 6, Out of Centre Development, and those are both policies of the Local Development Plan. There's no dispute that the established use on the site is Class 1 use, that the site is out of centre. There's no dispute on the methodology and conclusions of the sequential approach in the retail impact assessment by the appellant. There's no dispute that there will be no significant adverse impact on the vitality and viability of existing centres, again as assessed in the retail impact assessment. There's no dispute that the proposal is not intended to meet the needs of an expanding working population within the catchment area. And there's no dispute that there are no significant employment allocations in the local development plan within the catchment area. Now, before I go on to some matters that the appellant's raised, is the appellant content that those are matters where there is no dispute between the parties?
Yes, ma'am.
Okay, and Mr. Nelson, from the council's perspective, are you satisfied that there's no dispute between the parties in relation to those matters?
Yes, ma'am.
Okay, thank you. That's really helpful. Now, the appellant also wrote last week in response to the draft agenda and added to that list some other issues with which it felt there was no dispute between the parties. And again, I'll just summarise these. It felt there was no dispute that the relevant guidance against which the accessibility of the site for retail development should be assessed is set out in Planning Advice Note 75 and Transport Scotland Transport Assessment Guidance. That there's no dispute that the social and economic benefits of the proposal are not in dispute. There's no dispute on the employment effects. There's no dispute on the transport impacts of the proposal, as no objection has been raised by the Council's Road Authority Department, and there's no dispute in relation to parking. Again, no objections have been raised, although there is an affirmative suggested in the consultation response from the Roads Department. So that's the appellant's view. These aren't in dispute. And I wondered, Council, you can give me your view in relation to these matters and whether you agree that there's no dispute in relation to them.
Ma'am, in respect of transport impact and parking, we'd agree both of those points that they're not in dispute. And in terms of the first three, I think we consider there's good scope in terms of a joint statement for much of those points to be agreed, but not for it to be quite agreed to the extent stated there. I'm not sure without starting into evidence whether I can really go much further than that just now on those three. But it's not quite as far as that. But in terms of a joint statement, we do think we could get those aspects limited right down in terms of the areas of dispute on those issues.
And the last one on parking.
Apologies, ma'am. So yes, transport impact and parking were both aspects that are agreed.
Mr. Armstrong, is there anything you want to add before coming with my views?
Not really, ma'am. I mean, that's helpful for Mr. Nelson to set out that position and indicate that there is scope for the certainly aspects of the first three bullet points to be agreed by joint statement. I would have thought there's considerable scope for agreeing that, considering in relation to the first one, obviously the government guidance is set out in the PAN and it's mirrored in the transport assessment guidance, and there doesn't appear to be any point taken in relation to these matters in the report to committee. Also in relation to the second point, that there doesn't appear to be any dispute taken by the council in the report to committee. And on the third point, whilst I accept that the report to committee points out that that there are existing there is an existing retail unit on the site, and there perhaps are issues in relation to net and gross employment in relation to the gain. I'm sure that has got scope of being agreed in a joint minute, or a joint statement, should I say.
Thank you. In my view was, I thought they hopefully could be agreed in the joint statement or agreed minute. My own personal view was, having read the papers, I did feel the first point on the guidance on which to assess accessibility was agreed. I think, Ms. Nelson, you did agree that point when you just commented on that there. Sorry,
ma'am. So relevant guidance, it's certainly relevant guidance. I suppose it's just in the overall context of it being part of the picture, not necessarily the full picture, and maybe that statement as just an overall statement we might take issue with, but it is certainly relevant guidance. There's no doubt about that. And certainly this was just really why we were saying in a joint statement we could put it clearly as to being a position we could jointly agree over its status and role. And then I think Mr. Armstrong probably reasonably fairly summarises the points on social economic benefits and employment effects as being aspects that is sizable agreement over, but there are maybe still some issues that will need to be just highlighted in terms of a joint statement as being what remains in disagreement or differing views between the parties.
Okay, that's helpful. That was my view reading the documentation before me, that a lot of it is agreed, but there's probably nuanced points, as you're saying, about displacement of jobs, whether they're new jobs, displaced jobs, the social and economic benefit, whether that's pointing to a quality deficiency or not. I think there's nuances around that, but hopefully a lot of it in the joint statement could be agreed. And as you say, you can highlight the areas, narrow down where there's still dispute or difference of views between the parties. So that's been really helpful, just for my benefit, to understand the things I can almost put to one side as not being disputed, and the things that I think we need to focus on as part of the oral sessions. Now, I set out in the agenda my provisional assessment of the issues I felt required oral evidence. And again, for maybe watching, I'll summarise these. These are the catchment area for the proposed store, and that was in particular to how this was defined, the influence of similar in nature stores, and whether it should be based on an identified operator. Also, the population in the catchment area and historic and predicted growth, housing allocations in the catchment area. I also thought we needed more evidence in relation to the accessibility of the site, bus stops and routes serving the site, how easy walking distance is determined, whether by radius or walking time, the number of residents within easy walking distance, whether there's a quantitative deficiency within the catchment area, the purpose and relevance of the Edinburgh Commercial Needs Study, the retail measure study by the Council, the justification for consequence of the 50% reduction in turnover of Morrison's and Portobello Town Centre, and finally I thought we had evidence on whether there's a quality deficiency within the catchment area. Now, before we move on to another point that the appellant suggested, I think from the appellant's letter that I got, I think, is it right to say the appellant's generally happy that I've captured those issues that are in dispute? Mr. Armstrong, do you want to comment?
Yes, ma'am. We'd agree that these are the key issues, and as you point out also in your agenda 4.5, we do mention RET 1 and RET 6, but perhaps they could be tied in with these key issues, because, ma'am, I suppose that your first bullet point, the catchment area, well, that is very much tying in with RET 6A. And the third bullet point is, I suppose, tying in with RET 1 and RET 6D, and the fourth bullet point is again back to RET 6A, and the fifth one, RET 6A. We mentioned the policy point because we are unsure of the extent of whether there is an issue between the parties in relation to the interpretation of policy, in particular RET 6, and obviously the wording of 6A sets out the proposal will address a quantitative or qualitative deficiency, or will meet the needs of an expanding residential or working population within its catchment area. And it's obviously the appellant's position that the ors mean that there's only a requirement to meet one of these to comply with RET 6A, and we're not sure whether that is the council's position or not. So there may well be an issue there, which I think could be dealt with under the issues that you've identified, rather than a sort of self-contained topic.
Nelson, what's your views?
Certainly, ma'am. So, in terms of 4.4 and the issues you've set out, I think we would certainly agree that those are the principal matters that do seem to merit oral evidence in terms of the complexity. In terms of the policy matters of RET 1 and RET 6 and their meanings, I'm certainly open enough. Clearly, it's a key issue in terms of understanding those policies, and they need to be understood in terms of being able to look at all the other issues. So whether that is by further written submissions on that to fully understand that, whether you think that's the appropriate manner, or indeed it being part of the hearing, we're certainly open to it either way. We recognise they are the key policies, and they do need to be understood, and that does need to be brought out.
Thank you. I think my initial view was perhaps further written submissions, but having heard what we've said today, if we brought it into some of the other sessions rather than having a standalone session on it, I'd be happy to incorporate into one of those sessions. Because I agree, it's important we understand what we mean by the policy and how I should assess the case. And if it was brought into one of the oral sessions and then followed up in your closing submissions, from my perspective, I think that would be sufficient to allow me to have enough information on that, if everyone's content with that approach.
Yes, ma'am, we're content with that. I think that would work very well.
Yes, certainly, ma'am. I suppose both parties could clearly set out the policy position within their hearing statements, which might help, and then it can be dealt with more generally in terms of the various points against that as having the context of what both parties think on it within our hearing statements.
I think that'd be really helpful, and then we can narrow down the issues when we get to an oral session to focus on those areas where there is dispute, because I think that in a lot of areas there is no dispute, but there are the 2 or 3 points around the OR and within its catchment area as part of the policy where I think there perhaps may be a difference of opinion. But if that was, in your hearing statement, or we'll come on to the process that was set out, we can then look at that in the oral sessions. So that's really helpful that we've got some kind of consensus on the areas that we think we need oral evidence on. The appellant also raised in their recent letter that appropriate conditions should be considered if the appeal is upheld. Now, I did request further written submissions on conditions, and my understanding from the Council's response is that it does not consider that any conditions are required, but has proposed 4 informatives. And obviously from the appellant's documentation from their application, their appeal statement, they propose 1 condition which sets limits to the permitted net convenience floor space. Does that remain the parties' positions? If I start with the Council first, does that remain your position that there should be no conditions but 4 informatives based on where we are today?
Yes, ma'am. I think the original permission on the site, I believe, dates back some 20 years, and I think all other issues that were conditions then are dealt with and don't stand. And the only one that really is still of relevance is the one that the Section 42 concerns. And therefore, the council's view looking at this was that if granted, there wasn't a necessity for any conditions, and I've just set out the informatives.
Okay, having heard that, Mr. Armstrong, my view is I don't really need to have a session on conditions, if that's the Council's opinion. Clearly, if I go through the oral sessions and I'm minded to grant and I get to the position I feel there should be conditions, I could come out with further written submissions to the parties to get views. But I'm not really convinced at this point I need to have any oral session on it. I just wonder what your view would be.
Well, ma'am, obviously the appellant is suggesting the condition that's set out in paragraph 1.7 of the planning statement for the appellant. There is also in the transport statement there is also a suggestion that having a travel plan would be attractive. And that could potentially be another condition. Ma'am, I'm happy not to, standing that we now have the council's final position on that. I'm happy to leave it to perhaps putting in my closing submission that the appellant are offering these conditions and just setting out the wording, the potential wording of the condition in the statement is set out on page 2 of the statement. I'm happy to deal with it in that way if you're content with that.
I'd be content with that. It may be something that we end up touching on in the context of an oral session, depending how the evidence comes out. But I think we can leave it at that. I don't think we need a separate conditions oral session, for example, to discuss the possibility of 2 conditions. Okay, so that's really helpful. Thank you. So I think we finished item 4 on the agenda. If we go on to item 5, this is based on looking at the method and the date of the oral sessions. Now, it said in my agenda that I was minded to hold hearing sessions rather than an inquiry. And I did note, and the appellant reiterated in its recent letter, its preference would be to have an examination undertaken as a public inquiry, or at the very least that the evidence should be heard within a hearing type format with opportunities for the parties to interrogate the evidence presented by the others. Now, I am going to ask both parties for their views on the procedure for the various items that I've split out. And when considering what your response should be, can you just bear in mind the following? First of all, the purpose of the oral session is to enable me to obtain the evidence I need to determine the appeal. That's what this is about. I need to get what I need to get to a conclusion, an outcome on this case. Where we stand today, any oral sessions will almost certainly be virtual. I can't see any circumstances where we'll be meeting in person at this point in time, given we are with the restrictions. And I know that brings its own challenges when it comes to inquiry, about people being in the same room, liaising with your experts, things like that. Now, that's not insurmountable, but I just want you to bear that in mind. There is no scope within a hearing for cross-examination. Now, a hearing is a roundtable discussion and it's chaired by me. And although the parties can route questions through me, and there'll be an opportunity in receipt of their draft hearing agendas to suggest further areas or lines of questioning, there is no cross-examination. So with that in mind, I'll start with the appellant. I just wonder if you can just confirm or reiterate what the preferred method would be for doing the oral evidence?
Well, Ma'am, obviously in normal times or normal circumstances, I would have thought that this would have been the issues that you've identified would be ideal for an inquiry session to deal with them. They fit into the criteria that's suggested under Guidance Note 8 for an inquiry session. But we appreciate that these are not normal times, and we do appreciate that there are considerable difficulties in holding an inquiry session by way of video link, and there are fewer difficulties, and certainly in my experience, hearings have worked well that I've been involved with in relation to planning appeals. With the hearing session procedure, and I think it does work quite well, but by video. What we would suggest is that you, ma'am, obviously have considerable discretion as to how a hearing session operates, and that discretion does allow questions to be put by one party to another party through you, if you consider that these questions are relevant to the discussion. And we would be content to leave it at that and proceed by way of hearing session on the understanding that if there are matters that we consider that it would be important to put to the other side, that you would give us an opportunity to suggest questions to you that could be asked during the hearing session. We appreciate that it is up to you to decide whether you think that that is a relevant question or whether it is a question that is helpful. And we also appreciate that the priority is for you to understand the evidence and ask the questions that you feel are pertinent to be asked. But in these circumstances, we would ask for a degree of leeway to particularly, I was thinking in relation to the issue in relation to the fourth issue that you've identified, and whether there is a quantitative deficiency within the catchment area, that there are a number of technical issues in relation to that, which it might be helpful if questions could be asked through you in relation to these matters. But on that basis, and having regard to the circumstances that we all find ourselves in, the appellant accepts that it would be appropriate to have hearing sessions rather than inquiry sessions in relation to the 5 issues that you have identified.
Just before going to Mr. Nelson, just bear in mind what you said. If just the 4th session was an inquiry session and the others were hearing sessions, would that help? If that's one where you think there's potentially more technical issues and more questioning?
Ma'am, that would help. I appreciate that there are some difficulties with conducting an inquiry session by video link, but they're not insurmountable. That would certainly help.
Okay, just thought I'd just test that, because I agree with it. Inquiries are more challenging, but they're not insurmountable. We can work around it. We can set up some protocols, and I want to make sure you feel you've had sufficient opportunity to test the case and put your evidence out there. So, Mr. Nelson, what would your view be on that from what we've discussed?
Yes, ma'am. I think the council's view on all the issues, it is capable of being dealt with via hearing, certainly in terms of what the modern form, I suppose, of how hearings are conducted these days, and having a detailed agenda and a detailed set out of the points. And as you've highlighted, the fact that it's a draft is circulated first, and if parties think there are issues or aspects missing off that do need addressed in terms of getting to the bottom of the evidence, that can be highlighted to you to enable that. I think for all the issues, that should suffice in terms of allowing a detailed examination of it led through you. I think with no difficulty on the point that, as always, it is open to both parties to ask questions through you, and you can allow or reject those, provided those sit within the confines of the topics that have been identified and the subtopics that have been identified, and are not something that is totally new and different that parties may not have had a chance to consider or prepare for in terms of answering. But yeah, other than that aspect, I don't think there's any issue with it. I think if plainly it's not insurmountable if you consider an inquiry session on one of the topics is necessary. Yeah, and just yeah, provided it's all done virtually, I think that's possible from our witnesses' points of view. And yeah, it would just be timing then, I suppose, in terms of the preparation bits, which we'll come on to, that would maybe impact it in terms of that, and to lead in times of when it all can take place, if we've got to factor that into the equation. Thank you, Matt.
Okay, thank you. That's really helpful. Based on that, I'll look again at bullet point 4. I did think that was probably the most technical one about the 50% reduction. I'll look at that again and see where I think it should be an inquiry session. The other 4, I think we should definitely do hearing sessions. And I am happy to circulate the agendas in advance and allow parties to suggest lines of questioning, further detailed questions, and we can take it from there during the hearing session. In the circumstances, I will probably allow a little bit of leeway, but I will not allow, obviously, new issues to come up or issues that people haven't had time to prepare for, with no ambushing as usual. But we can work through that, and I think that should be manageable going forward from a virtual point of view. Now, if we assume it's 4 hearing sessions and inquiry session, let's just assume that at the moment, so we can think about timescales. Now, I'd flagged up in the agenda that I was thinking of holding oral sessions week commencing 15th March this year. Now, I'm working on the basis that we might still be in lockdown and we might still be homeschooling. Now, I might be the only person affected by homeschooling, I don't know. I can manage that, but the week I can't manage is the week commencing 22nd of March. So I'm assuming we are lockdown. So I cannot do week commencing 22nd March, but I'm available the week commencing 15th March and the week commencing 29th of March. And I would like to conclude the oral procedure before Easter, and having a timeline, and bearing in mind I suppose the narrow nature of the issues that we're looking at. I know they're fairly wide there's a lot in the topics, but we have identified, or I've identified quite simply, the areas we want to look at. I think it is doable, albeit it is quite a tight timetable, but I still think it's manageable. So I'll come on to the timetable in a minute. On those weeks, the appellant's already confirmed that they can do the week commencing 15th March, but not the 15th of March, which is fine. Can the appellant do the week commencing 29th of March?
Yes, ma'am. I mean, obviously, our preference would be the earliest date possible, and I think we did suggest also the week before the 15th March. But so our preference would be the earliest date possible, but we would be available for the week commencing the 29th as well.
Okay, thank you. I know you're available the week commencing the 8th. I felt that was just maybe slightly too tight to allow parties sufficient time to produce their statements and to prepare. That was particularly when we're preparing virtually, which is the reason I've discounted that week. Mr. Nelson, what's the council's availability like for both those weeks that I flagged?
Thank you, ma'am. I think we'd agree about the 8th of March being too tight in terms of timescales. We certainly will obviously be coming on to the other deadlines, and I think it may be shaped by that a little bit. And I suppose I think it's probably helpful to touch on that just now in terms of just saying what my thoughts are on the dates. Is just in terms of, I suppose, documents and then hearing statements, and indeed anything from the inquiry stuff as well, is just whether it's really, I would probably suggest it's necessary to have probably a 2-week period between documents and then hearing statements, because you're going to have to take cognizance of those hearing statements, those documents and everything that's been produced in terms of finalising your hearing statement. I suppose we've also got to work out when the joint statements need to be agreed and how that feeds into the hearing statements and indeed any inquiry evidence. So I suppose just when you take that, and I suppose when we were looking back at what that did to the dates potentially, and that made it extremely tight, I think, in terms of almost taking you back into the end of January, if you were going ahead on the 15th of March. So the 15th of March, if that's what you could decide, certainly we generally could do that. We maybe have some limitations on the 17th due to committee and various commitments, I suppose, within the team in terms of Council's planning committee. But otherwise, that week is possible. I think you've said 22nd of March is out for yourself. 29th of March is indeed possible for our team, and I think that would be our preferred timing for this. Subject to maybe working through the inquiry timescales, and that's all doable in terms of timings. But if that's what we're doing, that yeah, and certainly as you've noted, after that you're into the Easter holiday period, and there's difficulties with that. I think we have reasonably good availability after that if we ended up there, but those next weeks are not, because yes, there are people within our team that, like yourself, there's the childcare issues.
I mean, I'd like to get this done before Easter. I don't think there's any reason why we can't get it done before Easter. But that's helpful to know that those weeks are okay for everyone. I've noted your comments about the 17th of March. So we'll come on, well, before we set the date, we'll know those 2 weeks are free and people can make them. The number of days required, my initial thinking was 2 to 3 days, and the appellant actually came back with their thoughts were 2 to 3 days as well, funnily enough. Now, being prudent, and on the basis that I know from experience of other reporters and people who've taken part in virtual hearings and inquiries, that the sessions tend to be a bit shorter than if you're in person, because I think looking at a screen can be quite tiring for people, particularly witnesses. It's quite intense. We tend to try and build in more frequent screen breaks, so people are kind of walking away from the screens maybe 5 minutes every hour, because it is hard for people to concentrate for that amount of time. So the inquiries and hearings that we've done tend to be spread out over more days. So I was thinking of setting aside 4 days, just to make sure we had ample time to make sure we had buffers in there to give people a bit of respite from looking at the screens and listening to evidence all day. And that should be ample time to structure the sessions in, even allow maybe for the 17th of March, if you had constraints, Mr. Nelson, to allow us to conclude all the evidence within that period, and ensuring we don't have to kind of reconvene any later on in the year. Would everyone be happy with setting aside 4 days, just to make sure we have got ample time? Mr. Armstrong?
Yes, ma'am. I mean, I think we'd certainly would get it. We'll definitely get it finished within 4 days, as we set out. We thought it would be 2 to 3 days, but we do appreciate that a sort of a video day is it does sometimes seem a lot longer than a normal hearing session day. But yeah, yes, no, I think it could comfortably be dealt with in that time scale.
Mr. Nelson?
Yes, ma'am. I think our estimate is similarly. I think I've managed to miss the fact that the appellants have said 2 to 3 days, but that's certainly been our thoughts this last week when we were looking through it. And indeed, we'd be confident with that, and it seems sensible just to take that cautious approach of 4 days, or indeed it being 3.5 at least, to just make sure that we get there. And I suppose other factor in why the breaks, or it's more of a strain, is also that I suppose you end up having the meetings between your team that you can't easily have within the room as you normally would, in terms of just discussing aspects and dealing with aspects, have to be done virtually as well. So that just adds to the strain, I suppose, in terms of doing it virtually. Certainly, definitely from doing this before, it was a more tiring experience, I think, in terms of the days than dealing with it in a physical form.
I mean, there are things I think we can do virtually, like having little virtual rooms you can go into and discuss the case during the process. If there's breaks, you can have a virtual room for the council, a virtual room for the appellant, to manage that discussion, because I know it is critical when you've got your team that you can discuss when the evidence is being heard. But we can probably work through that. But I think if we set aside the phase, that would just give us a little bit of breathing space to factor in a bit of downtime from looking at our screens. Now, the appellant, you raised the issue about arrangements for observers. The intention would be to again broadcast the oral sessions live, so that would allow anyone who is interested to to kind of connect in and watch either live, or they can watch it later on if they so wished. And that should hopefully satisfy that. If we have an inquiry session, we do have to give notice of that anyway to the interested parties, so they'd be aware of what was happening. So on that basis, I think we should set aside 4 days. So if it was week commencing the 15th, it wouldn't start on the 15th, because I know the appellant's got issues on the 15th, so it would be the Tuesday to Friday. And if it's the week commencing the 29th, it would be the Monday to Thursday, because the Friday's Good Friday. And once we've got into the timeline, we'll look at how both those weeks shape for both parties. So is everyone content with that so far? Albeit I haven't nailed the dates to the mast yet.
Yes, ma'am.
Thank you. Right, if we go into the prior disclosure of cases, now as you all know, there's a number of written exchanges which need to take place before the oral sessions, and this is to ensure that each party is fully aware of the case to be made by those on the other side. So if there's an inquiry session, so that if bullet point 4 is dealt with by inquiry session, I would require an inquiry statement from both parties. This must provide details of the case you're putting forward, set out a list of the documents which are to be referred to, and specify the witness who will give evidence and the scope of the evidence they will cover, and who will be leading the case and cross-examining. Now, based on my timeline, if we had an inquiry session, and there will only be one inquiry session on matter 4, and bear in mind what you said, Mr. Nelson, about having 2 weeks between say statement and then documents, I would propose that the inquiry statement would need to be lodged by the 1st of February. And in the event the inquiry was the 28th of March, that would be the 8th, I was going to make that the 8th of February. Now, given that there is only one inquiry session, I would hope that would be doable within that time frame. Given we're, I suppose, starting from next week commencing the 18th of January, that would give 2 weeks to put that together on the basis of 15th of March. Now, for the hearing sessions, I would require obviously a hearing statement, and this must provide full details of the case that will be put forward, list the documents that will be referred to, and specify the witnesses that will take part and what they cover. Now, before I come on to when I would expect that to be submitted, you also obviously submit your documents, and they would be anything you want to rely on, including reports, plans, photographs, etc. Now, there already is a lot of evidence before me, and it may be that there's not too much to add to what's already been submitted by the appellant, by the council. I don't know, I'm not stopping you adding documents in, but there's quite a lot of evidence before me anyway. So based on that, I was proposing the documents would be 15th of February, assuming a 15th of March inquiry. And if we're assuming a 29th of March inquiry, the documents would be the 1st of March. Hearing statements, and this may be where we have to maybe rejig a little bit. The hearing statements would, and the precognitions, which obviously need to be produced by those giving evidence at the inquiry session, and they've got to be no more than 2,000 words. So hearing statements and precognitions would need to be submitted if we go for oral sessions 15th of March on the 22nd of February. And if the oral sessions are the 29th of March, they would both be the 8th of March for the hearing statements and the precognitions. I would like to have rebuttal statements if we have an inquiry session on that 4th point. And they would need to be submitted in the case of an inquiry starting in the week commencing 15th of March, on the 1st of March, And for the 29th of March, that would be the 15th of March. So before going any further, Mr. Armstrong, what's your view that timeline I've just outlined?
Yes, ma'am. I think I'm happy with these dates and times, and think that they both would work. I wouldn't anticipate there being many more documents being lodged, because you've obviously got a considerable number of documents. Indeed, there's a fair degree of duplication between the council and the appellants in relation to some of the documents. So I wouldn't have anticipated. I know Mr. Nelson suggested that that might be an issue, but I wouldn't have thought certainly it's an issue in this case, because you really do have all the documentation, or virtually all the documentation before you. So I think all of these dates can easily be managed. There is the issue of an agreed statement as well, which might sort of cut down some of the requirements for evidence, and I certainly think that we could start the ball rolling with that, and perhaps produce an agreed statement in the next, as I'm looking at Mr. just in the next week or so, to certainly get the ball rolling in relation to that, and perhaps reduce the amount of information evidence that has to go into any statements or other documents.
I think that'd be helpful. I was going to come on to agreed statement. My preference would be for that to be lodged as a document at the same time as the documents are lodged. But I think I would agree it should help to reduce what requires to be in, for example, precognitions and the hearing statements, which would come after the documents being lodged. Mr. Nelson, your view on the timeline and what needs to be done?
I may have missed it, but I suppose it was, and it may not be critical in this case, was just inquiry reports, I suppose, because it may be that both sides think actually if we end up with a one issue inquiry, it's perfectly dealable via recognition, rather than that inquiry reports being within the documents, and it then being a case of that being considering those in terms of the precognitions that are being considered. Exactly. I take Mr. Armstrong's point that it may well be that there's not very substantial additional documents, but if that aspect is needing to be factored into the equation, then a week is still pretty tight between documents and considering an inquiry report and producing, finalising hearing statements and finalising recognitions and submitting them. So I would still submit in terms of having that 2 weeks there would be highly helpful in terms of timescales of actually, and yeah, in terms of certainly the council's team and competing workloads of actually being able to discuss any matters with them, then having only a week there is potentially very tight. But it maybe does depend a little bit in terms of whether inquiry reports would be envisaged in this case. Otherwise, I think dates do work, and I do welcome the suggestion of a draft joint statement being produced as early as that. It may well, if we go ahead with an inquiry session, it may well shape, I suppose, inquiry statement as well as hearing statement and a lot of what's being prepared. So if there's at least a draft that's going back and forth from that early stage that can help limit that down a little bit, and taking your point absolutely that it needs to be lodged and finalised as a document in advance of the hearing statements and precognitions, then that would be very helpful. Yeah, I think otherwise dates are okay, but there seems a little bit more scope if it's that later date in terms of meeting all that.
Mr. Armstrong?
Just to come back, I wouldn't have thought there's any reason for an inquiry report document here. I mean, obviously the council have their report to committee. The appellant have their detailed statement, including retail impact assessment, and their appeal statement, and the council also obviously have their response to that. I wouldn't have thought there'd been a need for a sort of further document in that context?
I have to say, I wouldn't have thought so either, and I wouldn't be advocating people submit inquiry reports just to repeat what I've already got before me in a different format. I've got what I've got. I've read what I've got. I expect the practitioners to kind of bring that all together and for someone to present the case in the form of that practitioner. So I was probably not expecting inquiry reports in the context of this case. I'm kind of reassured Mr. Armstrong says. Does that give you some reassurance, Mr. Nelson?
Yes, if that's not a factor and that's not expected from their end, then fine. If we're keeping recognitions within the normal lengths and then having the chance for rebuttal as well, then that's all helpful.
Okay, that's all really helpful. Based on that, I am minded to go with the 15th of March for the inquiry and the hearing sessions. I think it is manageable. I think the areas are quite clear, the areas that we need to have more evidence on. And I think if the appellant can ensure that that agreed statement is drafted and with the council within the next, maybe say even 10 days, next 10 days from today, I think that would be very, very helpful, and allow us, hopefully both sides, to really focus on the areas that are in dispute. On the assumption we're going to do an inquiry session, and I will confirm that, I do intend to get the note of the meeting out by the very start of next week, just so you've got it and know exactly what we're doing. I am minded towards that inquiry session, one inquiry session, 4 hearing sessions. I will issue protocols about how we're going to run the hearing and inquiry sessions. We find for inquiry sessions, for example, it's very helpful if before the inquiry session, parties list all documents they're going to refer to, not to try and show your hand, but just so everyone get the documents on tabs on their screen. So that when we're going through cross-examination, everyone just can click on rather than trying to download a document or trying to find it. It just speeds up the process, makes it slightly more efficient. So I will set out some protocols. It's not to try and prevent you doing what you normally do at an inquiry session. It's just to make it easier for every party because we're not all in the same room, and to make sure everyone's on the same page the whole time. I did mention about having a single document list, and again, this is just for ease, to make sure we're all working off one document. We're not trying to go through a council document list, a core document list, an appellant document list, and getting muddled up and trying to download documents, because things are naturally slower when we're all online as well. We found that. So I know the appellant's happy to produce a first draft of this. And again, as there's likely not to be very many more documents than what I've got, that should hopefully be fairly straightforward. And again, if that could be kicked off sooner rather than later, that would also be helpful, and would give the council probably some assurance on the document side. There's no indication at this point that there's any legal submissions coming forward. But if anyone is considering that, please do it as soon as possible, or as soon as the issue comes to light. Do not wait until the first day, please. It just delays the process, and it's contrary to the spirit of prior disclosure. So that's just a wee warning to everyone there. I know things can arise, but if there's anything you think about, please tell me sooner rather than later. The appellant also requested closing submissions. Now, I think that probably would be quite helpful, particularly if we've got the inquiry session and the hearing session. I think these should be made after the close of the oral sessions. The council will make their submission first, and the appellant a few days later. I had thought, if we're going for the week of the 15th of March, which is what we're looking at, that the council would have until the 26th of March to put their closing submission, and the appellant would have until the 1st of April. So it's a few days after that. Also takes account, I think that takes account the weekend as well. And again, I think that hopefully be manageable for both parties. Mr. Armstrong, do you think that sounds doable?
Yes, ma'am.
Mr. Nelson? Oh, I think you're mute.
Sorry, yeah. Sorry, I hadn't quite unmuted yet. I'm trying to bring up the calendar as well, just to look at it, that was all. I think yeah, it's from our perspective. I suppose ideally, if it was possible to be a week later than that, that would be preferable in terms of just I suppose the difficulty I'll have is if we're tied up for 4 days with this and other people are tied up with it, they will have significant other aspects to deal with on the return to the office. That's just the reality of it, and just pulling this together and finalising it and getting it to you, then that time would be helpful. But yeah, it's not unworkable.
I was trying not again to into that Easter period. I personally have no issue about giving you slightly longer if it didn't compromise Mr. Armstrong being able to do his closing submission slightly later too. Mr. Armstrong?
Ma'am, I would be keen not to perhaps drag on is the wrong word, but sort of postpone the closing submissions to a later date. I mean, they are. Again, the matters are focused here. I'd have thought these are not going to be exceptionally long submissions. I think it would be helpful to have them, and particularly if there's an interpretation point to be dealt with. But we would certainly be able to work easily within the timetable that you suggested of the 26th and the 1st of April.
And the only time we think about would be given the council say to the 29th over the weekend period on the Monday, and allow you to take until, I don't know if you're working Good Friday or not, or to the next Tuesday after the Easter weekend.
Um,
It should be Tuesday the 6th of April, building into that Easter holiday period. I don't want them to be too long after the process ends anyway, because it just, I just say it gets more remote from what we've heard. But if that gives the council just slightly more flexibility, that may help.
Yeah, we could. I'm happy to work with that with that timescale.
So 29th of March for the council and the 6th of April for the appellant. If it's sooner, if it's earlier than the 6th of April, please submit them. But it just gives you an extra few days. That'd be really helpful. It would just tie up the process shortly after we actually had the sessions. Okay, so moving on to item 7, the submission and deposit of documents. As you'll all know, all documents submitted should be shared electronically with all the parties involved and copied to the DPA case officer, which you've been in touch with, which was Christine Brown. I had suggested memory sticks because, again, it is easier to have it on a memory stick or on your computer or somehow, rather than trying to download it from the DPA website. They will all be on the website, but again, as you're doing the videoing, it takes a long time for a document to download, and some of them are several megabytes. I think the appellant's happy to provide these. One would go to the council, and the council, you'd have to make your own memory sticks for your team or do what you need to do. And once you come to me, now I'll confirm in the procedure note where that should be sent to, just logistics of getting it to me and the timing and everything else. But I'll confirm that in the procedure notice, and if the appellant's still happy to do that, that would be hugely appreciated.
Yes, ma'am, we're happy to produce that.
Okay, great, thank you very much. Now, during the period of the COVID-19 restrictions, the council is not required to place the material on deposit anywhere. We will publish everything on the website, on our website, so it is available to the public. So turning to site inspections, our current guidance is that at this point in time during the current lockdown, we cannot do site inspections, either accompanied or unaccompanied. And if any local area is in Tier 4, if we come out of the lockdown, which hopefully we will at one point, we cannot do an accompanied or unaccompanied site inspection in a Tier 4 area. Now, subject to that, I intend on my premises to carry out an unaccompanied site inspection before and, if necessary, after the oral sessions. I know the site, and I obviously know Edinburgh, I know the site. I'm familiar with the general area, but there's certain things I just like to familiarise myself with if I was going out before the actual hearing and inquiry sessions. I don't need to be accompanied. I'll be kind of wandering around. It's more to wander around the catchment area, see what's there, some shops, things like that. If the restrictions are still in place, I do think I'm familiar enough with the site to continue with the oral sessions. The Chief Reporter has also said that in certain circumstances, exceptional circumstances, there would be some dispensation given to reporters to allow them to do unaccompanied in-person site inspections to allow cases to progress. And I would hopeful that this kind of case would fall into that bracket, and that we've got oral session dates set, and therefore it'd be advantageous for me to go. So on that basis, are you content with that? The ideal is I will still go out, and I will still wander around and do what I want to do before. I will also do something afterwards, hopefully because restrictions have been relaxed even more and I can go out and take more time over it. But is everyone content basis? I don't really want to have to postpone the oral sessions to a point where I might be able to do a site inspection, because who knows when that could happen. We will work around that flexible within the DPA, and we have got dates set. I will be given dispensation to go. I'm not going into any properties. I can walk around Edinburgh by myself with a mask on if necessary. I can do it relatively safely within the strict rules that I will be given. Is everyone content for us to proceed on that basis? Mr. Armstrong from the appellant.
Ma'am, yes, we are content with proceeding on that basis. We also, I think, suggested that we could produce a map, sort of suggesting some of the routes, particularly in relation to the pedestrian routes, that it might be helpful for you when you have the opportunity to walk down, and we could produce that with the document list, I suppose, if that would be of assistance.
I think that would be of assistance. To be fair to the council, if you're producing plans like that, or for me to look at or follow on a site inspection, it would be useful for the council to comment on those or provide any alternative plans or routes they want me to see. So I'm looking from both parties' perspectives on that. So ideally, if they were produced, I'm not saying they need to be agreed, because they don't need to be agreed, but if they're produced and people can comment on it before documents are lodged, so I know that what our positions on them are, then that will allow me to go out and do a site inspection. I just want to make sure that I'm looking at it from both parties' perspectives, and if the council have suggestions on pedestrian routes, then I'd like to look at both if I'm out on site. Is that okay?
Ma'am, I'd be intending to sort of share that plan with the council, and hopefully,
okay.
I'm sure we will reach agreement on that. Yes, no, I think that would be the best way of doing it, rather than you having two plans. Or
yeah, that'd be helpful. If there's one plan showing various pedestrian routes, that would be absolutely fine. I can go out and I can make my own views and own judgment on those routes. That would be really helpful. I just want to make sure that I'm representing both parties' views on likely routes to the site and things like that. But if you can do that and liaise between yourselves, and then submit a document to me, that would be really, really appreciated. I listed in the agenda the various things I was going to look at. I've kind of touched on that. It would be the catchment area, other stores within and out with, but close to the catchment area, location of bus stops in the vicinity of the site, walking and cycling routes to the sites from the catchment area, walking distances and times, patterns of roads, footpaths, things like that, location of residential areas, and new major housing sites and housing allocations and recent consented areas. So that's what I was focusing on. So again, if you can show some of that on a plan for me, that would certainly help when I was out on site. Is there anything else you think I need to see? It maybe you think no at this point in time, but it comes out when you're looking at the plans. But is there anything at this point in time you think I need to go and look at specifically?
No, ma'am, nothing else. No.
Ma'am, so just coming back on those few different things, there is council's quite content with that approach in terms of site visits. We're well aware from a planning perspective of the restrictions around that just now. And in terms of your list of things you're intending to see, we're quite content with that as well. On your plans point, I absolutely agree with that. If we can, we'll jointly agree a plan. That would certainly be the preferred approach in terms of trying to show everything on the one plan. And failing that, then clearly we can both be submitting and sharing what we've submitted to you in terms of our thoughts on the subject. But hopefully we can avoid that. Thank you, ma'am.
Okay, thank you. So item 9, as usual, any queries you have for the DPA about the oral sessions should be directed to Christine Brown, the case officer. I know Ms Hargis and Mr Nelson will be in contact with her anyway. I will include her contact details in the note of the meeting. when I circulate that. And as I said before, I will ensure that is sent out to parties at the start of next week on Monday, so that you've got that and it sets out clearly the dates and everything else. So I think that takes us to the last matter, if there's any other business. Mr. Armstrong, is there anything else you'd like to raise at this time?
Nothing else, ma'am.
Mr. Nelson?
Sorry, I took a while. No, ma'am.
Okay, well, that's been really helpful. I think it's worked quite well today, so thank you all for your participation. We will go for that week commencing the 15th of March, starting on the Tuesday, the 16th, for 4 days. I'll set the key dates in the note of the matters, which will come out next week, and that will also go onto the DPA website. So really, all I've got to say now is I'm going to formally close the meeting, and you can all hang up. It's a new way of the world, isn't it? But thank you very much, and we'll be in touch with from the case officer next week.
Thank you, ma'am, and thank you to Graham for getting this set up for us all. Thank you.
Thank you.